But just so we get a sense of what we're talking about, criminal protections also are individual protections. That's why they are a subset of civil liberties. So the Fourth Amendment provides protection against unreasonable search and seizure. So it says the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Search and seizure law. The Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime. But the part we're interested in is, nor shall any person be subject for the same offense twice, or in a criminal case to be a witness against himself. So when we talk about the Fifth Amendment, the main thing we're talking about there is this idea of self-incrimination. Miranda rights. What the heck is Miranda rights? You've seen it on television shows. You have a right to be silent. If you choose not to, whatever you say can be used for you or against you in a court of law. You have a right to an attorney. And then they'll ask you, are you knowingly waiving your rights? Now that part, these Miranda warnings, are not specifically stated in the Fifth Amendment. They've been implied by the courts in the United States Supreme Court in Miranda versus Arizona. We have the Sixth Amendment, which calls for speedy trial, the right to confront witnesses, and the right in the criminal case to have assistance of counsel. And then we have the Eighth Amendment, which bars cruel and unusual punishment. So the question becomes, what is cruel and unusual punishment? What do we mean by that? Now when we talk about the second major element here, we were talking about civil liberties, and now we're going to talk about civil rights. Civil rights deal with issues of discrimination and inequality under the law. So discrimination is the denial of privileges to persons because of their gender, their race, their ethnicity, their religion. What's referred to as immutable characteristic. So to what extent can we treat people differently in regard to education, voting, the courts, marriage, housing? And that's what the whole issue of civil rights deals with. And obviously for some of you, you're also taking my course on civil rights and discrimination, and we're talking about race, gender, and sexual orientation discrimination, and to what extent are these things protected. And when we talk about it from a constitutional law perspective, the major component of the Constitution that deals with civil rights is the 14th Amendment. The 14th Amendment. And the 14th Amendment, as part of this, says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the states and of the state wherein they reside. They say, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deprive any person of life, liberty, or property without due process, nor deny to any person within its jurisdiction the equal protection of the law. And that's the phrase that's used most prominently when dealing with civil rights and discrimination cases. Well, When we talk about civil liberties, when we talk about civil rights, one of the things that you have to understand is that none of these are absolute rights. So the question becomes, how do you apply them? So even if you look at the most basic of our rights, even if you look at the most basic of our rights, so look at the First Amendment again. And it says, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech. What does that mean? So does that mean you can practice whatever religion you want, no matter what? Does that mean in the name of freedom of speech you can say whatever you want? So if you want to practice devil worship, and you want to sacrifice the Vestal Virgin every month to the devil god, are you allowed to do that? And can you say, you can't prosecute me because this is my religious belief? If you want to be able to say anything you want, is that protected? So can you go to a movie theater that's crowded, and this is a famous example given by the Supreme Court, and get up and start screaming, fire, fire! And then everybody gets up and starts trampling each other trying to get out to save themselves, and you go, ha ha ha, freedom of speech, isn't it great? Well, the point is, and the reason we use those kind of extreme examples, is that none of these rights are absolute. None of them are absolute. So think about what we're saying there. There's limits on these rights. So then the question becomes, so how do you apply them? How do you apply them? How do we know? And this is where the United States Supreme Court becomes a very important player. And it's an important player in terms of understanding their role and their approach to these kinds of constitutional law issues. So, a Supreme Court justice can be considered a judicial activist or a strict constructionist. So judicial activists are judges whose judicial philosophy, which includes treating the law as a vibrant and an active source of rules. So when faced with new issues, these types of judges are likely to see the Constitution as what they refer to as a flexible, living document. And they're often referred to as pragmatists. So they have to deal with issues like same-sex marriage, birth control. And they can come up with reasons to say that these are protected by the United States Constitution, even though a strict reading of the Constitution would say our founding fathers never considered the issues of same-sex marriage or birth control. A strict constructionist is a judge whose reading of the law narrowly interprets the legal words and subscribes to an interpretation that the law must be consistent with the meaning given to it by the drafters. So the law only means what our founding fathers meant when they wrote it. So if they didn't contemplate abortion, they didn't contemplate same-sex marriage, well then obviously there's not a constitutional protection. So this is an important concept. And it's more important as we try and understand this idea of what is the power of the courts, and specifically, what is the power of the United States Supreme Court in regard to the interpretation and application of the United States Constitution. Now, one of the things we have to remember is we said that the original Constitution gave us Article 1, Article 2, and Article 3. And Article 3 was the judicial article. It's the article that establishes the United States Supreme Court. But there was a glaring omission in the Constitution, in Article 1 or 2 or 3. It never specified who the final arbiter of the meaning of the Constitution was. So when we talk about interpreting and applying the Constitution, who has that power? Who has that right? It's not in the Constitution. But it becomes settled by a very important Supreme Court case, and I don't know if I put that one down. We did, okay. Marbury versus Madison. So Marbury versus Madison was decided in 1803. And it's a complicated case. What happened is President John Adams, who we spoke about before, appoints William Marbury to a judicial position as a midnight appointment. So what does that mean? Well, what it means is President Adams was the incumbent president, just like, say, President Trump is now, and let's assume Trump were to get beaten by Biden, okay, at that point, he would be the lame duck president, and if he does any appointments, they would be considered midnight appointments. He wants to get these appointments done before Biden can come aboard and appoint more, from what he would see, communists to the Supreme Court. So, as we said, Adams appoints Marbury to this judicial position as a midnight appointment. Adams had been defeated by Thomas Jefferson. Adams was a Federalist who believed in strong national government. Jefferson was an anti-Federalist who didn't believe in strong national government. And what happens is Marbury's commission inadvertently was not delivered by the Adams administration. So when Jefferson takes office, Marbury goes to Madison, who was the Secretary of State, and it was the Secretary of State in those days who delivered the commissions, and said, please give me my commission. And Madison says, no, why the heck is he going to give a commission to someone that they didn't appoint and they don't want? So Marbury appeals this case directly to the United States Supreme Court. United States Supreme Court. And the Chief Justice of the United States Supreme Court was John Marshall at the time. And he was a Federalist. And to make things even crazier, he was a midnight appointment. And to make things even crazier, he was the former Secretary of State in the Adams administration. So he didn't forget to give himself the commission, but he certainly forgot to give Marbury the commission. So this is a complex case, and Marshall understood that President Jefferson would monitor this case very closely. So he didn't want to upset Jefferson because it's the inception of our nation. Nobody's too sure how powerful the courts are supposed to be or not be. So Marshall tried to figure out a way to decide this case without upsetting President Jefferson. So what he did, came up with this brilliant political solution. He held that the Judiciary Act of 1789, which Congress had passed and gave the United States Supreme Court jurisdiction in these types of cases, was unconstitutional. So he dismissed the case. And he said that only a constitutional amendment and the Constitution itself can specify the court's jurisdiction, because, as we know, Article 3 talked about the jurisdiction of the United States Supreme Court, and it didn't say anything about it having the power to do these kinds of things. So if you want to change the jurisdiction, the only way you can do it is through a constitutional amendment. Well, that made Jefferson happy. Good. Go away, Marbury. I don't have to give you anything. But Marshall was very shrewd. Marshall understood that in making this decision, he was asserting a more important power. The power of what we call judicial review. Judicial review. It is emphatically the province and duty of the Judicial Department to say what the law is. Marbury versus Madison. So in other words, when you talk about the most important power of the United States Supreme Court, the power to unilaterally apply and interpret the United States Constitution, it is a power that the Supreme Court gave itself. Gave it to itself. It's not specifically authorized anywhere in the Constitution. Nowhere in Article 3. So with this declaration comes the awesome duty of defining by the United States Supreme Court of what the Constitution means and what it doesn't mean. Okay. So that's very important to understand. Let's break. This one I'm